This is Rushi Patel, Associate General Counsel for the Georgia Municipal Association. GMA is proud to present Part 1 of this webinar, Weapons in Georgia's Cities, Navigating Georgia's Laws on Firearms, Weapons, and Local Governments. Part 1 deals with existing laws and changes to existing laws. This presentation should not be used to substitute for timely advice of the city attorney. Municipal officials should rely on their city attorney to apply the law and judicial interpretations to the specific fact situations they face. In some instances, relevant statutes have been summarized to address key points in a concise manner. The opinions expressed in this publication should not be used or taken as legal advice. It's time for a little history lesson. The United States Constitution's Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Georgia's Constitution also has a provision on the right to bear arms in Article 1, Section 1, Paragraph 8. This provision reads, "The right of the people to keep and bear arms shall not be infringed, but the General Assembly shall have the power to prescribe the manner in which arms may be borne." There are many existing prohibitions already on cities. Cities already were prohibited from many types of firearms and weapons regulation before this legislative session. This means many of the current prohibitions will still be in place, even after House Bill 60, the major gun legislation of this session, becomes effective on July 1st. Cities cannot have policies that allow the city to search private vehicles of employees or invited guests in city parking lots. This is current state law, and it will continue after July 1st, 2014, and it's found in 16-11-135. City employees are allowed to have firearms in their vehicles parked in city parking lots if they have a valid weapons carry license and the firearm is locked out of plain sight, unless the parking area is controlled by a gate or security personnel. So the only time a city can prohibit firearms in a parked vehicle is if there's security at the gate, at the entrance to the parking lot, or if there's a gate securing the parking lot. Cities are prohibited from regulating gun shows, firearms dealers, dealers and components of firearms, and the transfer, sale, purchase, licensing, or registration of firearms. This is current law, and it actually goes into more detail than is written on this slide, and it can be found in 16-11-173B1. Effectively, this means cities cannot pass ordinances regulating gun shows, firearms dealers, and the sales, transfer, purchase, licensing, registration of firearms. There cannot be local laws on such topics. That same code section says cities are prohibited from enacting any ordinance or resolution which regulates possession, transport, or carrying of firearms. This includes transport, carrying, or possession of firearms within city parks, city-owned property. City parks, you cannot have ordinances or resolutions regulating the possession or carrying of firearms or weapons. There are some changes. The prohibition on city regulations of possession, transport, sale, licensing, registration, ownership, or carrying of firearms, gun shows, and firearms dealers is going to be expanded to include weapons and dealers of weapons after July 1st, 2014. So the question is, what are weapons? Unlike other parts of the Georgia law, the law governing dangerous instrumentalities and practices, the term weapons is not defined in the part of the law covering city regulations governing possession, transport, licensing, sales, registration, ownership, or carrying. So weapons is not defined in this part dealing with ordinances such as in city parks. It is defined in 16-11-125.1 and 16-11-127.1, but neither of those definitions of weapons applies to this part of the law governing possession, transport, sale, licensing, registration, ownership, or carrying of firearms and weapons. The meaning of weapons as applied to this part prohibiting these such city regulations almost certainly includes knives, but whether it includes other types of weapons is undefined and unclear. With all that said, cities should consult their own legal counsel, but a broad interpretation of the definition of weapons for that part of the law, which is 1611-173b1 again, should help keep the city out of litigation. So if the city looks at this term weapons for this part of the law and says it's not defined, the city would be wise in looking at a broad interpretation of that definition in order to keep the city out of litigation. During the 2014 legislative session, a comprehensive firearms and weapons bill, House Bill 60, passed the Georgia General Assembly and was later signed by Governor Nathan Deal. This is the major firearms and weapons bill of the legislative session. However, House Bill 60 was not the only firearms legislation that passed during the 2014 session. House Bill 773 relating to the discharge of firearms near roads and House Bill 826 relating to carrying of weapons in school zones were also enacted. Now, House Bill 826 was signed by the governor the day before House Bill 60 was signed, and because many of the sections in House Bill 826 also appear in House Bill 60, which provisions of House Bill 826 become effective law is still being discussed and deliberated. However, House Bill 60 and House Bill 773 concern city governments, and those are the bills that we're concerned with in parts 1, 2, and 3, which is all the parts of this presentation. The provisions of House Bill 60 and House Bill 826 become effective on July 1st, 2014, while House Bill 773 is already current law and effective upon the governor's signing. What do these new laws mean for our city? The legislative changes to the state's firearms and weapons law were very extensive. The remainder of these presentations, parts 2 and 3, will address some of the major changes step by step. Part 2 will concern government buildings, while Part 3 will cover courtrooms, polling places, and other buildings which may have been concerned to city elected officials and city police. If there are any questions, city employees and personnel are encouraged to consult your city attorney for any legal advice on how to apply Georgia law. Part 1 of this presentation has been presented by Rushi Patel, Associate General Counsel of the Georgia Municipal Association, and my email is rpatel@gmanet.com.